What will you be teaching this term, Kunal?
I'm teaching jurisprudence.
Not evidence law?
Evidence was last trimester.
Okay. And you're only teaching research methodology this term, Mrinal?
Yeah.
Where are you right now, Neha? Delhi?
Yeah, I'm in Vidhi. This is our Vidhi office.
Okay. Is it cold there?
Not really.
Okay.
People attending classes from Delhi are in full thing and you're saying not.
As in, enough for a sweatshirt, but not cold.
Okay. Not Delhi cold.
No, not yet. I think that'll happen in Jan.
Yeah.
Let us start. Okay. So good morning, everybody. I'm here with Professor Mrinal Satish, who's a professor at NLSIU. He teaches criminal law, criminal procedure, sexual offenses against women, and research methodology. And with Kunal Ambasta, who is an assistant professor at NLSIU, who teaches evidence law and jurisprudence at NLS. Mrinal has been a teacher for both Kunal and me. He taught us both criminal law and procedure. So we are in August company today. Okay, so before we start with what reverse burden of proof is, I thought I'll open this to the both of you, what presumption of innocence is in the first place and why it is a central tenet of criminal law. What makes it a central tenet, when it became a central tenet, and yes, so that's my question to begin. Mrinal, why don't you take it for us?
Okay, so I think as everybody would be aware, I think the presumption of innocence has been considered now for nearly 100 years to be a basic tenet of criminal law and criminal jurisprudence emerging from the Wilmington case and Wilmington principles, of course, on questions of burdens and standards of proof. So I think to understand this in a particular context with the entire machinery of the state investigating you and you as the accused as being a single individual being put up against the machinery of the state, I think presumption of innocence emerges therefore as something that is absolutely essential, that the legal system believes that you're not that you'll be given a fair chance to through the process, so basically a fair trial right as well, and that you will be presumed innocent, and the burden is on the prosecution to show that you have that the ingredients of the offense that you have been charged for are satisfied, and that it is proved from the context of the Wilmington principle that I mentioned earlier, proved beyond reasonable doubt. Right. And I think, of course, I'm sure we'll get into this conversation as we go ahead. And it's also been recognized in international human rights instruments, including the ICCPR and others, that it is also a basic tenet of one's human right. And the recognition in most system based on rule of law principles that you're presumed innocent, and it's the role of the state or the prosecuting body to show that you have that you satisfy the ingredients of the offense.
So even in Wilmington, they carved two exceptions to this presumption of innocence, right? One insanity and one statutory provisions, and presumed innocent except for insanity and statutory exceptions. So what we see in India right now is that you are creating more and more statutory exceptions to this presumption of innocence. But even in 1935 with Wilmington, they had the statutory exceptions. So this is a question that I'm throwing open to both of you, and even I don't know the answer to this, but and I've wondered is what exceptions even within a statute should theoretically allow for presumption of guilt or reverse onus of proof. Yes. So this is to both of you, because I have, of course, worked extensively on NDPS, and we'll get to this at what happens on the ground is, of course, different from what one expects to happen in the legislation. But even if one was to just think of a scenario theoretically where this would be okay to do, what would that scenario look like?
May
Yeah,
I
Go ahead.
Kunal. Yes.
Yeah. So I completely agree with Professor Mrinal about the presumption of innocence. I also think that if you take it as a principle, this presumption of innocence, it's brought into effect through different mechanisms. So presumption of innocence also encompasses within itself, let's say, the right to remain silent that we give to the accused. It encompasses within itself the standard of proof on the prosecution, which is beyond reasonable doubt. It encompasses several other statutory, non-statutory mechanisms as well, such as provisions of legal aid, that you will be given a lawyer if you cannot afford one, etc. Coming to the statutory exceptions. Well, if you look at presumption of innocence in that light, that it is effected through different principles. One mechanism could be the high standard of proof on the prosecution. One standard could be the fact that the prosecution bears the burden of going forward in a trial and of proving certain facts. Now, there are certain mechanisms that in certain situations are allowed to ease this burden on the prosecution. So, for example, let's take the reverse onus clause or the presumptions that operate in criminal law. And you find that these presumptions are also quite old. The Indian Evidence Act has several reverse onus clauses in its provisions, etc. The crucial difference becomes, what is the nature of this reverse onus clause? Is it something that is reversing what would be called in criminal law a fact in issue in the trial? So are you reversing the burden of proof with regard to, let's say, mens rea?
Yes.
Or are you just reversing the burden of proof with regard to any other relevant fact? And that's essentially the crucial difference. And you mentioned NDPS Act. There are several other provisions like this coming now. So if one looks at the POCSO, Section 29 and Section 30, it becomes very clear that what is being reversed is actually a burden of guilt, not a burden with regard to a particular fact, but with regard to guilt itself. And that, I think, presents a challenge to understanding presumption of innocence, because you're taking away a mechanism which affects the presumption of innocence in the first place.
So, Kunal, a follow-up question, because you've said this and you've brought in the Indian Evidence Act. This is a difference that we, in the criminal law parlance, would be evidentiary fact and persuasive, right? So, can you, and you've said proving a fact versus proving mens rea. Can you explain this a little bit? Because I'm guessing most of our audience or a lot of our audience would be lay. So, what does this mean?
Yeah, burden of proof under evidence law can mean two things. One is the burden of going forward, and which is also called a legal or an evidentiary burden. And the other is a burden of persuasion. Now, the burden of going forward is simply to produce any evidence. So, for example, let's say a case comes to trial. We know that the plaintiff in a civil case and the prosecution in a criminal case has the burden of starting the trial. You must start by presenting some facts, some evidence, etc. That's merely a burden of procedure. But there is a different understanding, which is the persuasive burden, which means that if I claim a particular fact to be true, I must also show to the court using evidence up to a particular standard, whether it's prima facie for the issue of, let's say, an interim order, whether it's preponderance of proof for a civil case, and whether it's the question of beyond reasonable doubt for criminal guilt. I must also show now that my evidence meets that standard. I must persuade the court to that extent. Now, the Indian Evidence Act has both these kinds of burdens in its provisions. If one looks through the act, you find that Stephen might have been talking about both of them. And it would still be okay if, let's say, you reverse a burden of persuasion also with regard to certain facts, right? Which in the circumstances of the case seem natural that a particular person, whether he be the accused, would have knowledge of. The problem, of course, becomes in a criminal trial when you reverse a persuasive burden on a fact in issue. So the Indian Evidence Act characterizes facts as relevant and facts in issue. Facts in issue are those kinds of facts in Section 3, which either by themselves or in connection with other facts answer the question that is before the court. So a question of guilt, a question of mens rea, actus reus, causation, these can be facts in issue. Now the question is, can you ever reverse a fact in issue itself? Can you tell the accused that you must disprove a fact in issue? I can understand Section 105, 106 of the Indian Evidence Act talking about relevant facts. But when you say that I must prove that I did not have mens rea, I must prove something else. Then it becomes slightly dicey.
Okay. So I have again to this. Mrinal, do you have anything to say to
Yeah,
this?
so I want to go back to your initial question that you asked in the context of Wilmington and the exceptions that it makes. I think one thing that we also need to be aware of, especially looking at the judgments of the House of Lords at that point of time, is what's also happening in 1935 in UK criminal jurisprudence, right? And one thing that's emerging in the late 19th century and the early part of the 20th century is strict liability.
Hmm. Hmm.
And you have a lot of case law in UK from that point of time. It's again, those of you interested should read this in a bit of detail. It's fascinating case law at that point of time where they're talking about removing mens rea. Of course, that's what strict liability means, removing of mens rea. And once the prosecution proves the actus reus, the offense is made out.
Now, can you
Right?
just tell people what mens rea and actus reus is before we continue?
Okay, so mens rea would be the mental element, intention, basically intention or knowledge. Actus reus would be the wrongful act, that makes it a crime. So therefore, just to give an example, at that point of time, adulteration of milk was an offense. So adulteration of milk, what the state had to prove was that the milk was adulterated. I, as the accused, it would be convicted of the offense because the statute wouldn't require me to show that I intentionally did it or I knew that the milk was adulterated. Why were these laws required? They felt that especially with respect to food, which is why I gave the example of milk, especially with respect to food and alcohol in the terms of people, and there's the entire set of cases in the UK of police officers going to a bar and asking for a drink while on duty, and the bartender being prosecuted for giving a police officer a drink. It didn't matter if the bartender didn't know that that person was a police officer. So the status. But if you look at the case law again, ranging up to more recent times, they say strict liability should be only for those offenses which have less punishments. So for all of these things, the punishment would be either a fine or 1 week, 1 month, nothing beyond that. So they said that as the punishments become higher, there's a presumption of mens rea. You have to read mens rea into the section, even if the section is silent on it. So I think from there also we draw in this reverse onus clauses coming in. I think the initial understanding from Wilmington, the two exceptions, when they say that it can be statutory, they're not talking about NDPS type of statutory exceptions. They're talking about Tobacco Act, Food Adulteration Act, and I'm talking about UK Tobacco Act, Food Adulteration Act, or in the context of the US, what they call public welfare offenses, these things which had very minor punishments. There's again case law in the UK which gives points that all the 6 points have to be satisfied before you make something a strict liability offense. So that's how it started. And of course, with respect to insanity, there's a presumption of a person being sane, which is where you said that I'm reversing it because I, as the prosecution, will assume that you're sane. So I'm reversing it to you to show that you had some issue because of which you could not develop the mens rea. You couldn't develop intention or knowledge, and that's for you to show, right? So again, I think what we have done is we have corrupted, I'm using the pun intentionally, corrupted what were statutes meant for adulteration and drawn them to the extent which I don't think in 1935, even the Wilmington case thought of. And again, we should remember Wilmington was a case of murder. So they were saying in offenses against the human body, which had a high punishment, you cannot use some of these new principles that they were carving out to deal with what they felt was minor regulatory offenses.
Okay. So now this is a very interesting question to you, because the 2013 Criminal Law Amendment Act reverses the burden of proof. And
does it?
Doesn't it? Like, isn't lack of consent presumed?
No.
Isn't it? As in, isn't lack of consent presumed, and then the accused has to show that there was consent on the person?
I think that's always a big matter of. Sorry.
I was going to come after you, saying, given that you were just the part of Justice Verma committee,
I was part of the research team. I was not part of the committee. So let me also make that clear. But yeah, so I think there's always a confusion about rape law. There is no presumption of consent. There's no the burden
Lack of consent, right?
yeah.
Presumption
So
of lack
the
of consent.
burden is not shifted in non-aggravated rape, right?
Sure.
So the burden is in 376(2) and 114A of the Indian Evidence Act, which were introduced in 1983. Right. Again, context is the Mathura case,
Yes.
where you're saying that, look, if a woman in that context is taken to a police station, she says I was subjected to sexual intercourse without my consent. As long as the prosecution were to prove that sexual intercourse did occur, and the woman says that she did not consent, it shall be presumed that she did not consent, right? And it is up to the accused to show that there was consent, right? So for 376(2), of course, there's a lot of confusion that keeps coming up of whether 114A applies to 376(1). It does not. So therefore, there's no presumption of consent in the rape law, or 2013 didn't bring any of that.
Okay. So now this whole attack is gone. This is falling flat. But so for the NDPS Act in Noor-Agha, which upheld the constitutionality of sections 35 and 54, they have used the UK case law that and said that, again, applied to the statutory exception, and said therefore it is acceptable to have sections 35 and 54. And the fact that higher punishment should allow or should definitely have a presumption of innocence has been negated from that point onwards, which we see now a proliferation of statutes which allow for reverse burden of proof. So in Noor-Agha, they use public interest, and there is a law commission report which uses social interest as reasons to reverse burden of proof. Now, I wanted both of your thoughts on this public interest and social interest, because from what I know, these two terms haven't been defined. Yeah. What is public interest? What is social interest? And this is true across repressive legislations. Preventive detention can be allowed on the basis of public order, but what exactly is public order, apart from concentric circles, hasn't been defined. Yeah. So I just wanted your thoughts on what you think these terms mean and how dangerous these terms are.
Well, this is the problem, right? We are quite keen to carve out exceptions to our general criminal jurisprudence in creating special offenses and special statutes. And if you see, the common theme is that for some reason it is assumed that the ordinary criminal law is incapable of taking care of this.
Yes, yes.
And there is really no debate about it. It seems to be an argument that is considered to be correct. And therefore, the moment you find, let's say, a terror offense or an offense relating to narcotics, you say that we need a special law. And in fact, these special laws become the vehicles of introducing things and making exceptions to general criminal law principles, such as the presumption of innocence and several other things. Now, in Noor-Agha, which was decided by Justice S.B. Sinha, you can see Sinha himself struggle through the judgment to make sense of what he's doing, because he was a keen criminal law mind, and of course he understood the importance of the presumption of innocence. So he again starts to carve out this kind of an exception, even though in the judgment he says that the higher the punishment, the more procedural rights should be given to the accused. And then he starts to talk about how drug abuse or narcotic trade, etc., can be social problems and can lead to a lot of large-scale disorder, I guess. And what he does there is a very interesting kind of balancing act. Yes. So he raises the burden on the prosecution to prove the possession. He says you must prove physical possession or beyond reasonable doubt. Yes. And only then is this reverse onus clause saved. So there are lots of things to be said about the judgment. One is, should we be doing this kind of trade-off, right? Should we say that if you let's say raise the burden on the prosecution with regard to some facts, then the presumption of innocence can be compromised, or the presumption in this or the reverse onus clause becomes justified? Is that the correct way of thinking about presumption of innocence in the first place? That's one thing. The second is, of course, let's say the constitutionality being in question, Justice Sinha also says here that the presumption of innocence is a human right. Yes. He does not raise it to the level of fundamental right, which I think is very problematic, because if you look at Article 20, right, then these are elements of the presumption of innocence right there, that no person will be compelled to give evidence against themselves, etc., etc. So how can you then say that things that comprise presumption of innocence can be part 3, but presumption of innocence itself is not a part 3, right? So there's some inconsistency there. And I think the problem is, of course, that anything can be justified with regard to social need and governance needs, right? You can justify the same thing with regard to child sexual abuse.
Yes.
You can say the same thing for terror laws. You can say the same thing for narcotics. We have, in fact, our own Food Adulteration Act, which also uses reverse burden clauses. So there's no stopping it once
I,
it's.
this is the reason I also got so interested, as in, of course, NDPS gets one interest in reverse burden of proof. But recently, during the pandemic, there was a healthcare worker ordinance that the central government had come out with. And that also had a reverse burden of proof. They also had mandatory minimum punishment, and the same offenses had also been made compoundable. So they had done all of these things and also made them compoundable, which clearly, as in now, there is complete corruption of criminal law or criminal law processes completely. So I actually had follow-up questions to what you just said, Kunal. You said, you quoted Article 20, and then you talked about Justice Sinhal's decision. I think he said that the burden on the accused shifts to preponderance of probabilities, right? Not beyond reasonable doubt. Now, I want to, so from my experience, at least all the charge sheets that I read from Punjab when I was looking at the NDPS report, whatever NDPS there, is that all of them just say that the person was in possession of whatever drug, may it be opium, morph, whatever it may be, that it was found in a bag on his person, and that's all. And the person, and all that the person does in his defense is to say that the police has some vendetta against me and they're falsely accusing me of this. Because for them to say that they didn't have conscious possession of this would mean that they first have to accept possession. Then only can they say that they didn't have. So, and this is again a person agreeing to having committed at least the actus reus, right? So these terms, like whether it's Article 20, whether it's preponderance of probabilities that the Supreme Court or the High Court comes out with, what do we expect, or how do we think these will play out on the ground? What does this mean?
Of course. See, the thing is this: when you say the physical act of possession must be proved beyond reasonable doubt, how is a physical act of possession generally proved? The NDPS has its own search and seizure provisions with regard to how a search and seizure is to be done in the presence of a gazetted officer, or if the accused waives that right, then in the absence of that officer, etc. Now, let's say all of this has been performed and there is a mahazar, right? And the search document and the seizure document which records the fact of seizure. That is essentially, in most cases, enough, unless you point out some great error with the mahazar, or in the cross-examination of the mahazar witness, you make him recant some parts of the facts of the seizure. That is enough to prove it. And a judge usually, for relevant facts, a judge usually uses the standard of preponderance. Now, if they feel that preponderance is met, there's a very small step to saying that, yes, this possession has been proved. So if there's nothing wrong with the mahazar, and you can construct a mahazar even post facto which looks perfect, it is possible to do that. Mahazars are created in police stations on the house. A lot of cases are like that. And if you have a witness who has read the mahazar before he comes to testify, and he has read his 161 statement, and he comes and repeats all of that, then essentially the fact is proved. So there's no real difference in saying that from preponderance I've shifted it higher to beyond reasonable doubt for physical possession. The burden ultimately lands on the accused's head.
Yes.
So and now how do you disprove a proven mahazar? Right? That's the question. It's like asking an accused to prove custodial torture. How do you prove it? All the people who tortured you are on the other side. They are not going to come and give evidence that they tortured you. Yes. So how do you disprove a proved mahazar? How do you bring doubt to that? It's very difficult. It is, I suppose, for a defense lawyer also, it would be extremely difficult to be able to do this.
Mrinal, because again, I'm putting you in this criminal law teacher position.
Can I sort of add?
Yes.
So I think couple of things is like you mentioned, like Kunal also mentioned, these sort of emergency provisions which were meant for particular statutes sort of pervading into the criminal law. And again, going back to strict liability in the Indian context, I think the case of Mayor Hans George, M.H. George versus State of Maharashtra, is that classic situation where the entire world is trying to arrest the smuggler, and he lands up in an aeroplane, plans it perfectly so that he's not going to get off that aircraft, and sitting in Bombay airport, and you figure out a way of going into that aircraft that you didn't mention something in the flight manifest, and therefore I can pick you up from there. And the Supreme Court getting into this entire exercise of justifying what the Customs Department had done in that case. And I think that begins the slide.
Yeah.
Because from that point on, of course, there's a dissenting judgment there, but that begins the slide because you have, for one individual, reversed a lot of rules and principles that you had laid down at prior point of time. And now that case becomes the basis on
Precedent.
which, not only precedent for cases, but becomes precedent for legislation. Because you say Supreme Court has said something like this, so you continue doing that. Similarly, on the question of preponderance and beyond reasonable doubt, I think it was always clear that things, that defenses, right, or presumptions were always proved on preponderance, right? But around 2003, when the Malimat Committee was looking at this issue, Malimat Committee started talking about it should be beyond reasonable doubt for the defense as well, and actually bring down preponderance for the prosecution, bring it down to preponderance for the prosecution. So slowly you see conversations after 2003 starting to happen around around the questions of standard of proof, which were not really that spoken about prior to 2003. So I think there are these movements, either in terms of committees or law commissions, Malimat Committee, or Supreme Court judgments, will make us dilute some of these principles. Like Kunal said, if you look at the entire legal aid formulation that you have, and then you have the case of Ajmal Kasab, right? And then everything is reversed. Or bail, right? If you go back to Motiram and read Motiram once again, and then you read Justice Chandrachud's judgment recently in Arnab Goswami, you see that everything had been said by Justice Krishna Iyer ages back, and we are still not able to look at Motiram, because in between you have a Sanjay Dutt, in between you have all these 2G cases where, coming back to public order, social order, they say no, if the amount is high, then that is interest enough not to give you bail, right? Going against the entire bail jurisprudence. So this entire question of corrupting these particular things. And on the NDPS Act, again, taking from what you said, Neha, as well was what Kunal mentioned, we have Section 50. I'm sure every charge sheet you have read, you would have come across Section 50. Section 50 of the NDPS Act gives the procedure for search. It says, again, for those who don't know the section, it says that if I am being searched, I have the right to be searched by two gazetted officers. I have to be informed first by the police that I have a right to be searched by two gazetted officers. I can say, no, why don't you search me yourself? And all of that has to be recorded in writing. I'm sure, Neha, you have never come across a charge sheet where the accused said, I want to be searched by a gazetted officer.
Has not waived that right. Everybody
has not waived that right.
Yes.
And if you speak to accused, they say, what? I have that right? I was never told.
Yes.
Right. And of course, I've come across very funny Mahajar reports where one case I came across where the accused was a foreigner. So the police officer decided to write it in English. When write this 50 requirement in English when he was not fluent in English. So he used a double negative. Right. So he said that I have consented not to be searched by a police officer. Double not, right, makes it a positive. So except situations like that, comic, tragic situations where there were mistakes, I have never come across anybody who said that I want to be searched by a gazetted officer, nor have I come across a single case where there were pure independent witnesses.
Oh, no. They're all police witnesses.
Because you can't find any. And of course, there's enough case law to say you can't find people don't become witnesses, right? So in terms of the Supreme Court jurisprudence on NDPS, again, we have moved very recent cases on Section 50, as well as the requirement of independent witnesses. We have diluted that as well. right? And so therefore, in that context, now if you say reverse onus, I'm already done for because I've been found in possession. You have a section 50 which is not being implemented in the tenor in why it was put into the NDPS Act. So there's an absolute presumption of guilt and it's over, right? After the search, you're done for.
This is actually very interesting because, we say this, but police officers feel very victimized by the NDPS Act, interestingly, as in the level of rigor that is required of them in the NDPS Act, in the text of the Act, makes them feel very sorry for themselves. So whenever I've spoken to police officers, they're like, you don't see the injustice against us. How are we supposed to do this? And it's fascinating because NDPS has one of the highest conviction rates, I think, across all legislations, right? Like it's almost 90% across all states. So that level of victimhood that the enforcers feel is very interesting, and I don't know whether that's just an NDPS thing or whether they just generally feel victimized by life, but that seems to be like their running thread.
I think, just to go on that point, I think police do a difficult job, and we have to acknowledge that they're doing right. No, but what I am saying is this again, coming back to reverse owners clauses, and I think I saw this around the time when the Selvi judgment, when we were awaiting the Selvi judgment in 2009, when they were doing so-called truth serum tests on it, everybody was being subjected to narco because of the fact that you felt that an easy way of investigating crimes where I don't need to do the hard work that is required of investigation. Like I said, of course, police officer, you want them standing on streets for 24 hours at stretch and then investigate something complicated. So they do feel, justifiably at times feel victimized in this context. But again, it's we can't pitch the police officer against the accused for the fault in which we have as lawyers and judges conceptualized these laws and thrown it at them to implement it in a particular way.
Absolutely.
Police officers also feel victimized by Section 25 of the Indian Evidence Act. They feel that confessions should be allowed. They should be allowed to record confessions. And under certain special statutes, they were allowed. And everyone saw what was happening. You would not come across a terror offense in which the accused was not confessing to a police officer.
Or NDPS also, Section 67.
Yes, absolutely. So these provisions, of course, are not meant to ensure that guilty people escape the law, but they're meant to ensure that the investigation takes place according to some procedure. It does not go into what we can imagine it will go into. So that balance has to be struck, and I would say it has to be struck in the interest of the accused at any given point of time.
So I will come back to this because I want this to be like my wrapping up comments on, but anyway, before that, Mrinal wanted two things from you. One is we have been using preponderance of probabilities and beyond reasonable doubt again, and not.
Don't ask me to define it.
So just like explain it with examples. And the second question is to both of you: is what do you think we have these provisions? What is the purpose of reverse burden of proof? Why do we have them in the first place? So these are my two questions next.
Okay, I think to hazard trying to define preponderance and
examples is fine.
No, I think I'd go back to my evidence class, my evidence professor, and go back to how we try to define in that particular context. I think what you're generally told is preponderance is in terms of percentages, where you get to that 51% is where the fact is proved 51%. It amounts to preponderance, and beyond reasonable doubt does not mean beyond all doubt. So it does not need to be 100%, but yeah, in the 90s sort of thing. But again, I think it's so subjective. I don't think this 51s or 90s or any sort of example will serve the purpose, because ultimately it's you as the adjudicator who has to
decide whether
who has to decide. And you made a point earlier, Neha, and I think this again Kunal may be better placed to talk about this, is when you have a fact in issue, right, and a set of relevant facts. The question sometimes people get confused is, do you need to prove each element beyond reasonable doubt, or do you need to prove the entire chain beyond reasonable doubt? And now this sounds like fascinating abstract legal discussion that you may have of these elements, and the adjudicator might say, no, I figure out, right? I know when after looking at the facts, I figure out that
Yes.
this is beyond reasonable doubt. But of course, in evidence theory and evidence law, there are principles for each of these elements of whether you need to look at each fact, and if it's each fact, how do you go about how do you go about how do you go
Proving
about
each
that
fact beyond
each
reasonable doubt.
fact beyond reasonable doubt, or is it the chain?
So before Kunal answers, I just want to point out, so this is Mrinal's reaction that just happened was identical to how he used to react when we were in college. So he didn't teach us evidence. Somebody else taught us evidence, but we couldn't understand a lot of what was being taught. So we would flock to him. And this is exactly what he would say. Don't ask. This is not my subject. Don't ask me. This has been like, this was deja vu. But anyway.
I agree with what Mrinal is saying. See, if you look at the definitions under the Indian Evidence Act again, it defines proved, disproved, and not proved. Right? If you just take the definition of proved, there are two legs to that definition. And one can say that the statute is not insisting on a particular standard of proof there. One leg, you can reason the reasonable person standard, etc. But it also says where the court considers, after looking at all matters before it, where the court considers something to be likely to exist. So the impression one gets is that you can have different standards of proof for different kinds of facts. I'll give an example. Let's say I am a police officer, I go to a magistrate asking for a search warrant to be issued. Now, some facts will have to be placed before the magistrate, and the magistrate will test those facts on a very low standard of proof called the ex facie standard. Yes, there is a reasonable suspicion, there needs to be a search, so grant them the warrant. Let's say in a different context, I go to the court asking for an interim order, an injunction. Now the standard of proof is a little high, prima facie. When I go for a civil suit and I ask for the civil suit to be, let's say, decreed in my favor, the standard is preponderance of proof, which, as Mrinal was saying, is more likely to be true than not. So your 50% chance, just above 50% chance, meets that preponderance. There is another standard which is not really used in India, but it's used in the US, which is called clear and convincing.
Yes, new thing that I also heard. Yes.
Yeah, which is higher than preponderance. And it's used for civil cases with high stakes. So custody battles over children or class action suits are decreed according to the clear and convincing standard. So we are talking, let's say, around just very crudely, I would say 70% probability, 75% chance that this would be true. And then the final one is your beyond reasonable doubt, which is quite impossible to quantify in terms of a percentage. And as Mrinal was correctly saying, it does not mean the absence of any doubt. You can subject any fact to any kind of hypothetical doubt. But what are the doubtful alternatives that are reasonable have been foreclosed? And then you can say that beyond reasonable doubt has been met. Now, which fact is to be proved to which standard in a criminal trial is an interesting question, right? Let's say you are doing a criminal case. There are so many kinds of facts, whether the accused was present at the spot, whether there was motive, etc., etc. All these facts don't need to be proved beyond reasonable doubt. For them, it's okay if the judge feels that according to a preponderance standard, the accused would have been present or had motive to commit this crime. Now, what happens, and this is my understanding, I might be completely wrong in this reading also. So my understanding is that relevant facts are proved according to a preponderance standard. A judge, once the trial is over, looks at all of these facts that have been proved. And then he comes to a conclusion as to whether the question of guilt has been proved beyond reasonable doubt or not. So there can be a situation where the prosecution proves all facts, but still guilt is not found. But still the judge does not feel confident enough to convict. Because to that, the question of guilt, that higher standard. So let's take the case of the Arushi Talwar and Hemraj double murder case. The prosecution essentially proves all the facts that it sets out to prove. Let's say it proves that the house was locked, or the judge believes that the house was locked. It proves that there was some motive, etc., etc. But still a judge may not feel confident enough to convict, because not all possibilities have been answered. Not all reasonable possibilities have been answered. In such cases, the right of the accused would be to be acquitted. So that's how I view it. And the reading of the Indian Evidence Act, which does not give a clear standard to the word proved, perhaps is an indication that you can adapt it to different circumstances. It's not a rigid standard for all cases.
So this would be that each of these facts is on preponderance of probabilities, and the chain has to be beyond reasonable doubt.
The
right?
final fact, the final question of guilt has to be beyond reasonable doubt. If it's anything less than beyond reasonable doubt, it has to be an acquittal.
Acquittal, right.
Ideally speaking, of course.
That's not how things go at all.
Yeah, this is a question of inference.
Yes.
So, and facts in issue not mostly, but several times are inferred facts. Mens rea is inferred from different other facts.
Yes.
From the nature of the injury, let's say I stabbed someone 20 times. You can infer that I must have intended to kill. I was not intending to do anything else.
Yeah, that this wasn't an accidental stabbing.
Exactly. Yeah.
Correct.
So stuff like that. What was your second question? Sorry, I forgot.
What does the purpose of reverse onus? What does it do? Why do we have them in the first place?
Mm-hmm.
So the reason, because whether it was the NDPS debates, whether it is whenever they bring in these provisions, all they say is it's a serious offense. We need to deter further such offense, and they don't actually tell you why each of these provisions are being included in the legislation, right? So we have to infer, and from that infer, it is deterrence. They want to deter, but what and how are they supposed to help or aid in this deterrence?
Yeah, I have a slightly long response to this. So if Mrinal wants to go ahead, please.
No, go ahead.
So I've written about this separately as well. And this is where I have looked at special criminal statutes in the criminal justice system. Now, my argument or my understanding essentially is this, that the logic of a special criminal statute is often this kind of logic. And if you look at the parliamentary debates, etc., where such laws are introduced, it's the government essentially saying that we need a special law because our ordinary laws are not adequate. Now, why are they not adequate is a large question that's not really gone into. But there's a kind of already proved logic that because this is a special offense, a special statute is needed.
Yes.
Now, my second aspect is, how do you look at what is so special about these statutes, right? What do they do that ordinary criminal laws don't? So take anti-terror law, for example. If you wage war against the government of India, even the IPC sentences you to death. Yes. So substantively, you are not making a difference to the punishment. You are not adding a higher punishment because there is no higher punishment than death. So what's the crucial difference between a special law and an ordinary criminal law is essentially the fact that you make special procedural provisions. Procedural safeguards are taken away. That's the crucial distinction between a special statute and a statute that operates under the CRPC, etc. And you can highlight this through presumption of innocence being taken away, through reverse onus clauses, right? You can also see procedural aspects such as bail, procedural rights such as bail are denied.
Yes.
Right? So essentially, you don't need to convict anymore. You can just punish with an accusation. And you might be seeing this also happening across the country as well. There's the essence becomes that an accusation under the special law equals, in terms of being onerous enough, a conviction. So essentially, nothing really is added by this special statute. Things are taken away. Why do they withstand judicial scrutiny if they're doing this so clearly, which they are? The reason is that the judiciary also buys into this logic of this being a necessity. This you can see in Noor, you can see in PUCL, you can see in Kartar Singh, yes, that you just buy into the logic that this is a special offense. But if you really start digging in and asking, why is this so special? Why couldn't the IPC have been amended to include, let's say, terrorist organizations, membership of terrorist organizations as an offense? Why did we need a special TADA, POTA, UAPA, etc.? There's really no answer to that. So I think that they don't add anything. They just take away your procedural rights.
So Mrinal, do you have anything to add to this?
On why we are adding reverse onus clauses.
What purpose do this serve?
Right, again, the one thing, of course, that is said that, look, like you mentioned earlier, these are sort of public order crimes and social crimes which require us to look at it differently, which is why we need to take away these rights that are there in a general evidence law, which is like say, be it in the context of the number of days of remand or bail, as Kunal mentioned, or the reverse owners clauses. I think the initial understanding when we talked about presumptions was that these are facts that you know better than we do.
Yes.
So therefore, why don't you prove some of these bits, right?
Yeah.
When we again like talked about the insanity defense, yeah, you could say, right, you have information regarding your mental health, so you prove it rather than us going digging, looking for it. So proving beyond reasonable doubt and the burden of proof being on me does not mean that I disprove every fact as the prosecution, that I prove that every element that you could raise a doubt in, but I prove a set of facts, and if there's something contrary to it, it's upon you to use a defense, etc. I think that's how sort of presumptions were understood, that to some parts of it we can't, so it's up to you. I think again, in corrupting that, we've reached another point, like what Kunal was saying, where we say that no, you prove the non-existence of the fact in issue, so I'm asking you to do everything, and I will sit back like a defense would. If you look at the CRPC framework itself, right, look at the entire investigative framework. Coming back to our broader question on presumption of innocence, it presumes at every step that the person is innocent, which is why you have search procedures, you have arrest procedures in a particular way, right? Which is why the magistrate comes in so many times during the investigative process. The magistrate is to ensure that the presumption of innocence is being safeguarded at multiple steps that are happening there. And bail also is a presumption of innocence related issue, which we have forgotten, right? So keeping all of those in mind is how the CRPC is structured. And if you look at the trial process, right, especially in a sessions trial, you see that the accused really has no role to play. The lawyer for the accused, except cross-examination, has really no role to play. So therefore, of course, in movies, when everybody is jumping up and arguing at each other, is not the case, right? So therefore, when we're talking about reverse onus clauses, we are saying, no, we'll just turn that over. We will sit back and you do all the work to disprove the fact and issue that it actually did not happen. And so I'm putting a presumption of guilt on you, which is what more recent statute, beginning with the NDPS, started doing. So we tasted success there, right? And higher conviction rates and quicker trials and things like that. So which is where we say, like you mentioned, the recent amendments during the pandemic. I know that in, like say, government circle, in law reform circles, right now, the example everybody gives is POXO.
But
right?
this is, yes.
Yeah, because people believe it's working.
So this is exactly
whereas as someone who works on this issue, it is actually counterproductive.
Exactly.
Having some of this is actually counterproductive. But a general person, like if you speak to doctors, right, if you speak to the Indian Medical Association, which was pushing for these amendments for attacks on doctors, they genuinely believed that having this sort of reverse onus clauses, higher punishments, lesser days of remand, or sorry, more days of remand, no bail, all of which would actually lead to more convictions of people who attack doctors. Right? And so therefore there's a public perception that if you make procedures, increase punishments, lo and behold, things will change. But I think there's enough criminal theory, enough studies done to show that this will all be counterproductive and lead you to lower conviction rates.
So this is actually what I want. When I was looking at this, I thought, so deterrence has three prongs to it, right? Celerity, certainty, severity, right? Severity is ensured by mandatory minimums of 10, 20, whatever years. And reverse burden would definitely get you certainty. It should also ideally also get you quickness of punishment, which I don't think really happens in any criminal trial. Your pendency rate across whether it's NDPS or POXO is always above 80%. What I was wondering is that NDPS, clearly the certainty whatever has completely taken fruit. So you do have 90%, 80%, whatever conviction rates. But POXO, your conviction rates are about 30% average across the last 5-6 years. Mrinal, so
yeah, sort of, yeah. But I think POXO has its own very different issues. So
exactly. So that was my follow-up question, that we have started using these these provisions en masse across different kinds of legislations, not thinking that the context of that particular legislation might be different. So when you said
But
POXO,
sorry to interrupt, Neha, but I think again, going back to NDPS, again, based on your work, who are these 80% who have been convicted?
all users, of course.
No, I think, or carriers or couriers,
So
right, of
these
people. Yeah.
people are also users. They
Yeah.
eventually become peddlers, and they have maybe like instead of having 5 grams of heroin, they'll have 20. But they're not going to be. They're not going to have 100 or 200 grams of. So they're all usually small or intermediate quantity. Use intermediate quantity possession. In fact, NCRB has now started coming out with, has started breaking down NDPS data into possession for trafficking and possession for consumption. And most of your cases, if you have 14,000, you'll have about 12,000 for possession for consumption and about 2,000 for trafficking. This is not just a
Where?
Mumbai,
Across the country?
across the country.
Well, I think the situation in Delhi is very different then, at least.
Yeah. So I also, because I was informed of NDPS through my Delhi experience or who had spoken to in Delhi, I assumed that that's the case. But the rest of the country, it's not a very, it's usually for self-consumption that people are getting arrested and convicted.
Yeah.
And maybe that's changed over the last few years also. We don't know. And it's an easy conviction. So, NDPS might have high conviction rates of users, but POXO is not even managing to get like your bare minimum convictions. So when you said that reverse burden of proof can be counterproductive, can you, why is it counterproductive, or why can it be?
Okay, let me just begin with NDPS. I think because what I found in some of my work on NDPS in Delhi was the fact that most people, because we're talking about deterrence, that most people who were in prison under NDPS for possession of commercial quantities were all mules. And they were doing it, most of them, for the first time. Right? And why I say that is in part of our prison work, I did meet people there who said that they were traffickers and said that sometimes we need to ensure that somebody gets caught. So therefore, I'll find an auto driver, tell him I'll give you 50,000 rupees, and then inform the police so that somebody gets caught. So the statistics are also built in the process. Another interesting thing to see is why is it? And again, I'm not only talking about Delhi, and I'm talking about some things like the Arms Act in the city of Bhopal. If you look at the NCRB statistics with respect to Arms Act, Bhopal seems to be the most violent city in the entire country, where everybody seems to be carrying arms with knives on their person. But everybody strangely seems to be found under a particular bridge every night at a particular time with those. Right? Similarly, in NDPS, everybody seems to want to take that particular bridge to transport stuff, knowing that police is going to be there every day. Of course, Neha and I worked together in Dwarka, where there used to be an interceptor of the police for speed interceptors at the same place near the airport every day. So everyone who drove near that area knew that you have to slow down to 40 for that 1 kilometer stretch, because the interceptor would be there every day. And so if you are a person who's carrying drugs and you know it, why would you go on that road? Which also, I'm saying, brings back the procedural issues that I was talking about, or something that Kunal was saying, that does this mean that they've not been caught there, but it's actually in a police station? Or if I'm a judge and I'm seeing everybody is being caught at the same spot every day, should it not set something thinking of saying, why is this happening? So I think NDPS has its own sort of situations where you are trapping people of a particular class, particular social setting, and that's what's affecting it. Now, coming to POXO, I think POXO, for whatever reason, again, I think people felt that if you use the NDPS framework in POXO, it would help. As we know, in most POXO cases, the offender is known to the victim. And if you're telling the family that, look, if the person is convicted, the minimum sentence is going to be 10 years, which it's now, for certain classes of offenses. For certain others, it's going to be 20 years. You can have reverse onus, you can have whatever you want. The victim is going to come to court and say nothing happened. Right? Because of the fact, and this is a different point, not on reverse onus, a different point being that the higher you take the sentences, especially minimum sentences, it is very clearly shown that leads to higher acquittal rates. Right? So I think that's what, multiple things plaguing POXO. One thing is this high punishments, which leads people to victims and families to say, what's the point in if it's within the family, what's the point of sending this one person in the family off to prison for 10 years? Because that may be the person who's earning
Primary
for the
breadwinner.
family. Yeah, primary bread earner. Or even there's a thing of sympathy saying, I think, yeah, 6 months would have been fine, but 10 years is not something I can digest myself. If, again, people work in different ways. We as people who make laws might not think of some of these issues. One, the second is in POCSO, again, completely different issue, is the age of consent. Right? If you see the NCRB statistics, most cases in POCSO, more than 50% are in the 16 to 18 age group. Right? And if that's in the 16 to 18 age group and there are cases of consent, again, people are going to turn hostile irrespective of what sort of onus you're putting on them. And I think so one, of course, the definitional parts, the age of consent. Third, I think importantly, and it's again a different issue, in crimes like POCSO, I think it's very important to figure out when is your evidence, like when is your testimony in court taken, right? And with the I think with the overload of cases of POCSO, which are not really POCSO cases landing up in POCSO courts, if you're going to take the testimony 1.5 years after the incident, two things will happen. One, if it's a child, 1.5 years later, the memory of that incident itself is completely different. Of course, our laws say that you should keep in mind that is taken 1.5 years later, but it also gives 1.5 years for the accused to influence the victim, right? So we are not. I think my broader point is we are not targeting the problems in some of these areas of law, but going for shortcuts. Like, okay, if we have reverse onus clause, if we deny bail, we'll make process the punishment,
Yes.
right? And then fret about the fact that we're still not getting convictions, nothing is happening, because again, your problem was somewhere else and your solution is something else.
So,
Can I just quickly pitch in? Let me talk about what has happened with terror offenses for the past several years. So your conviction rates under the TADA have been abysmally low, around 1 or 2%, etc. And that raises very interesting questions as to what goes so wrong in anti-terror cases or in terror trials that you're not able to get convictions. One reason could be that the lack. So when you empower the police in such a drastic way, right? Even basic safeguards and basic procedure that they're supposed to follow, they stop following that, which leads to cases collapsing in court because they think that this statute is anyways so totally in our favor that we can keep doing. So there are cases where even the minimal safeguards under POTA and TADA for recording of confessions have not been followed. Your Akshardham attack case was one similar case, which finally the Supreme Court acquitted all of them. And it's very tragic as well because both the trial court as well as the High Court had given sentences of death. And the Supreme Court finally acquits. There can be no greater disparity in criminal law from going from a sentence of death to that of acquittal. So the police stopped following even the minimal safeguards. The second thing is this. Now there is a particular national agency which investigates terror trials, and they boast of a very high conviction rate under the UAPA. Right? Now, looking at conviction rate is one thing, but it might not tell you the entire picture. And I'll just take 2 minutes to explain this. And somebody should study this. This is a fascinating thing that's happening across the country, which has not been studied. In Delhi, this practice is called the Katti. And the Katti, that's how lawyers refer to it in Delhi. And it's spread to Bangalore and other parts of the country as well, which is essentially that a UAPA trial goes on and the prosecution drags its feet. So for 7-8 years, you are in custody because your right to bail is anyways non-existent. No sessions court judge is going to grant you bail either, right? And the trial keeps going on. You are in custody for 7-8 years. You don't know how long it will go on for. And you do not know what is going to be the outcome. For it can also be that you get convicted ultimately. You will be approached by the prosecution agency or someone on behalf of the prosecution agency or your own lawyer whom the prosecution agency will approach you, which will ask you to change your plea
To guilty.
to guilty, right? Now, of course, what happens in this particular case is that a person thinking logically from their side who has spent 8 years in custody might spend another 10 years in custody will opt for this. And how is that recorded? That's recorded as a conviction. Right? So
Yes.
your conviction rate can go high, but
Yes.
that person never really got a trial.
Yes.
Perhaps he would have been acquitted. We never know. So all of these things, and is this a violation of presumption of innocence? Absolutely. Right?
Yes.
You have taken away procedurally what you guarantee in theory. Is it happening? It's happening in Bangalore. It's happening in other parts of Karnataka. It's happening in Delhi. It's something that's widespread.
So, Kunal, this is very interesting. I think this ties up what Mrinal said and what you said. When I was researching on the NDPS Act in Bombay, there was a conviction rate of 99 point some percent. There was we looked at some 16,000 cases. There was only one case of acquittal across these 16,000 cases. So we thought that this was a phenomenon which was specific to NDPS in Bombay, where everybody was pleading guilty. They were entering the system in the morning, where they'd get arrested in the morning. They'd be brought to court by about 11, 12 o'clock in the day, and they'd be convicted out by about 1 o'clock, 2 o'clock in the afternoon, with like a minor fine from 100 rupees to 5,000 rupees, whatever, depending on the court. And this had been going on for the last about 4 or 5 years. And the state had, of course, boasted of its high conviction rate under this law and saying that they are bringing down the terror of drugs in the state. Then somebody else mentioned this happening in some NIA court and said that this is what they're practicing in Maharashtra. It's widespread. And I said, no, this is not an NDPS or NIA or even a UAPA problem. This is a criminal procedure problem. And this then ties into what you were saying, Mrinal, about process itself becoming the punishment. Where now, because everybody knows that the process itself is the punishment, you're going to do whatever it takes to get out of it. Now, even these healthcare workers, doctors, whoever saying that these things work, I wonder whether they think it works in terms of high conviction or whether they also recognize that the process itself is punishment. So let's get them in the process. Let's scare people into fearing the process of the criminal trial. So I don't think anybody thinks these laws are working in terms of high conviction rates. Everybody just fears the process of a criminal trial.
Everyone wants a special law in their favor.
In their favor.
Yeah.
So that they can, so that the process, they can scare the person, the accused person, by the process of it itself.
Yeah. But just one thing I'll add, Neha, this entire thing of Katti, etc., this is only possible if you have special laws.
Yes.
Because under the CRPC, I might have a right to bail. So I know that I might get out. Why should I plead guilty and take that huge risk? Can you imagine the risk a person takes in pleading guilty to a UAPA charge? He might just be sentenced to life, and that might mean natural life. Yes. But there's some kind of arrangement that they give them the sentence already served and then they are released. Right?
Usually, yes.
Why would I take that risk? I would take that risk only if the law is draconian like that.
Yes.
I haven't seen my family for 8 years. My life is passing me by. I was arrested when I was a 20-year-old mechanic, let's say. And now I'm 28. And I don't know when this is going to end. It's only made possible by these provisions that deny bail. These provisions that, in a sense, dehumanize the entire process. That totally take away your presumption of innocence. Then for what joy should I maintain my presumption of innocence? It's not any use of,
So this is some, when you were saying that does the judge not know, when you're seeing the same template charge sheet, case after case after case, this is very interesting. This is exactly the question I had asked, and I asked judges this, and I'm sure you also have asked judges this, but they do know, right? They do know that charge sheets are being made in the police station. They do know that it's the same charge sheet across. I asked a senior police officer once why they use template charge sheets. They said that if they file the charge sheet today, the case might come up for hearing 5 years down the line. The case might get rejected on the basis of a discrepancy in the statement of the police officer. So the police officer, to guard himself, just writes the same story across different whatever, so that he knows the story. He doesn't mess up on the story. So to me, every single step from the arrest to what the judge, everybody knows. They're all in on it. And it's a game that everybody is playing, and we keep wondering from the sidelines how they continue to play these games. At least.
See, I think one again, going back to Kunal's point on pleading of we do have the same experience with plea bargaining if you look at plea bargaining under the CRPC, people are not plea bargaining the IPC offenses, right? People are plea bargaining the Arms Act, the unlawful possession of Railway Property Act, all of these things which have minimum punishments of 6 months, 2 years, the maximum punishments of 2 years, 3 years, type of thing. And because we are so number driven as a country, right? It's your entire performance is based on your disposal, from the police to lawyers to judges. That it feels good to get rid of cases, irrespective whether you're innocent or guilty. So the 2 points. One is when you talked about asked me that question on process, whether people think want to make process the punishment. I wouldn't completely. I think agree with that. There may be people who think that way, but I think for a lot of people who are just seeing the TV channels that are on TV nowadays, or reading your newspapers, you think that the NDPS Act is a fantastic legislation that's working, right? Unless you are doing nuanced reading on POXO or NDPS or TADA, UAPA, you think you're putting people who are going to commit crimes into prison and they're there for 10 years. Why should they be getting bail? And I think the one point that we have not discussed yet is this understanding that there are so-called fast-track courts in all of these special fast-track courts in all of these legislations. So there is a presumption that, okay, if my special statute, I will get a special fast-track court, and my case, attack on doctor, will end in 6 months. Right? And people do get shocked when you say, wait a minute, it's ASJ 1. And what does ASJ? I think this was a practice across the country. All special statute ASJ 1. ASJ 1 has NDPS, MACOCA, POTA, TADA, UAPA, special legislation 1 to 100. Right? So everything is in that poor judge's court. You're asking that poor judge to finish all of it fast track. Right? And nothing is going to get finished in that process. And like Kunal already mentioned, I think that was a failure of 2013. Because in 2012, the government was going to phase out so-called fast-track courts because they were not working. In 2013, in the political atmosphere of those protests, they said, we will set up fast-track courts. So fast-track courts make a reappearance with a vengeance. And if you study fast-track courts, you realize that the conviction rates are one of the lowest. Sorry, not the conviction rate. I'm sorry. I think the reversal rates are one of the highest, because of the fact that you're fast-tracked to such a way that you're giving up on procedural rights which get reversed on appeal. But if I'm a common citizen wanting a special court for whatever I'm doing, it looks fascinating. I'm happy. It's only once the statute is done and you're seeing that nothing is happening fast, you don't care about reverse onus or whatever. You want the person convicted. All these things are put at, and that the person, you basically, of course, there you say, let him not get bail. And of course, it will depend statute to statute. Some statutes you'll put all these onerous things. Some others you won't. There you'll say, doesn't matter, let me provide bail to this person day one. So therefore, your entire thing of having a special law for yourself is gone. I think to the coming back to that question of people pleading guilty for a particular offense, something I'd written about in 11 years earlier in terms of police record keeping. Everything is there in the police station. So I believe I am pleading guilty to a small theft of a mobile phone, thinking that's going to be it. I'm going to get out today and that's it. But my name is there in the police station as a person who's been convicted for mobile theft. So tomorrow, any mobile theft, I am the first one who's going to get picked up to be asked, saying, are you the person who's stolen the mobile phone? So that's one aspect of it which people are not informed about. Right, when they're asked to plead guilty. That's one. Second, in terms of how even NTPS works, again, police officers have told me this person has nothing to do with drugs.
Chain snatching.
He's been doing chain snatching, but we have never found any evidence against him. But we know it's him. So what's the best way? I'll put him under an act where he's not going to get bail, so he's at least off the street for me.
This is
right. So therefore, you're using the law. There's something that child rights activists in Tamil Nadu used to regularly talk about. When there was no POXO, apparently, if you see statistics of NDPS in Chennai, it used to be very high. When Chennai is not a place where drug trafficking, it's not a hub of drug trafficking. Subsequently, when they spoke to the police, they realized that the police were finding it difficult. It goes back to Kunal's point. Police were finding it difficult to arrest people for child sexual abuse. So they said, which legislation can I put this fellow under? Yeah.
Easiest.
So therefore, that he will not come out and not harm these children, by which time I'll find evidence, NDPS.
Yeah.
Right. So sometimes, again, you said when everybody knows about it, everybody knows about it. This person is coming to court for you as a prosecutor, for a judge, for chain snatching every day, but is getting out every day, and is like, okay, fine, he's in. So that's the objective is to put this person behind bars. Doesn't matter what legislation it is under. So there is the process. You're not looking for the conviction. That pre-trial custody is like, okay, he was going to get 2 years for the theft. He's 2 years in for NDPS or something else, so doesn't matter. And I think that's where the sort of corruption of the system begins. When that starts becoming normal, then the entire presumption of innocent, guilt, everything goes out of the window because of the fact that some legislation, some offense, something is all put together.
It stops mattering as to how you're invoking these statutes and how you're making them work. And this is essentially the fact that if you proliferate your statute book with statutes like this, if you are going to toy with liberty in such a flippant manner, and it's always going to have public support. A lot of these special cases or special statutes are made after moments of social rupture.
Absolutely.
So you have a really big terror attack, and then you say, no, now we are going to have a terror law.
Yes.
And at that point of time, we as members of civil society for a moment forget that. So you thought that, yes, an ordinary person would think that, yes, someone like Kasab needs to be tried without mercy, or it doesn't need to be tried also.
At all, yes.
But you never thought that this law is also going to be invoked against college students and professors, etc. But if you open that door to the state and say, come take my liberty away in light of this big situation that has happened, the state will happily do that.
Yes.
So
There was an interesting, just to take on that point, there was an interesting survey that the New York Times did post 9/11, right? So I think on 18th or something of September 2001, they did a survey saying how many of you, whoever they surveyed, citizens in people of New York, how many of you are willing to give up your liberty to the state because to deal with this terror attack that happened. I think that 91% of people said, take away all our rights, all our liberties. You can read our email. Emails have just come. You can read our email. You can figure out whatever you want to do with us. But when you took that survey on September 18, 2002, it had come down to 20%. But using that, the Patriot Act was passed in October 2001. Exactly what public support there was for taking away all sorts of rights. And what ultimately happened? What did the US Supreme Court do when we're talking about role of courts? Slowly by 2005-06, they said, okay, this applies only to foreign nationals, not to our citizens. So they carved out exceptions to those laws and kept the laws. Which what happened in Kartar Singh, what happened in PUCL, in all the Indian laws, you carve out exceptions saying confession can be taken as long as you are following all of these guidelines. In a few years, those guidelines will not be
to matter.
Like yesterday's judgment, right? Of installing CCTV cameras with audio facility in all police stations, whatever thing. Now you're trying to set up something. I don't know how that will work at all, but yeah, tomorrow you'll figure out a way of beating those CCTV cameras.
Totally.
One. Or second, the CCTV cameras and police officers themselves have said that the CCTV camera will become the thing saying it is not in the camera. It's not being captured. So the custodial torture never happened because it's not been recorded.
They've done this already in one of these Bollywood movies, Ranveer Singh movie, where exactly this was done, where it wasn't captured on CCTV and therefore they were acquitted. But I just wanted to add something. This is something I recently found out. So you've talked about NDPS being used for child sexual abuse, etc., right? In the last few years, I think 2 or 3 years, I have been documenting detentions under PIT NDPS. And they detain about 70 to 80,000 people per year under PIT NDPS. And then I did a little whatever newspaper articles that I found. And these are all, again, your peddlers or users. And in addition to NDPS, they're now also detaining them under PIT NDPS. They let them go in about 6 months or so. So there is no end to what manner or roundabout manner they will use to get your same result. If it's not NDPS, then it'll be a preventive detention law. And Chennai has the highest number of preventive detentions in the country. So, or not Chennai, Tamil Nadu has the highest number of preventive detentions in the country. So if not this, then they'll use preventive detention.
Something is whatever is convenient at that point of
At
time.
that point of time.
Exactly.
Yeah.
Exactly.
So I have a final wrapping up. This is a more like a thought theoretical question. That when you know that your criminal justice system is so rigged against the marginalized, is there an onus on legislation drafting to be, as an, is that consideration an onus one must bear when drafting a legislation? Does that make sense? Does the question make sense?
Yeah, it does. And I think I want to tie up to something I was going to say earlier. I think of course, it's happened in India, but a fascinating study you can see, or not really a study, fascinating trend you can see is in the US, right? There's a documentary called The 13th on Netflix.
Yes, of course.
I'm thinking both of you would have definitely watched it. For people who haven't, right, it gives you how the criminal justice system.
It's on YouTube as well.
It's on YouTube as well. Okay, it's Oscar nominated, show. 1.5 hours takes you through the entire what's happening in the US criminal justice process. But you take one step back to that, again, coming back to politics, right? The US presidential elections of 1988, Greg Dukakis of the Democrats versus the senior Bush. And apparently senior Bush was losing and Dukakis was doing very well. And they're trying to figure out what can they stump Dukakis with. And they figured out that he was soft on crime, right? That he was this liberal guy who felt that there should be no death penalty, people should get their rights and all of these things. So that's where they trapped him in a debate where they asked him an offensive question to say that, look, if this man, and he had pardoned a man who had come out immediately and raped and murdered someone, and that had become a big issue. He was the governor of Massachusetts, if I was not wrong. And they said, if he had done this to your wife, would you have done the same thing? And he said yes. And there's another documentary talking about US elections. They say his advisors were sitting back saying, don't answer, because they knew if he says yes, that's the election, right? And so he loses the election. And the next candidate from the Democrats, Bill Clinton, decides that the one way to go about is tough on crime. And so therefore, the entire criminal justice system in the US collapses in the way we're talking about during the Clinton era, where drug offenses, this so-called war on drugs is increased. All these presumptions, increased sentences, everything is brought in during the Bill Clinton era because they felt that's the way to win and continue winning the second term with that. And very interestingly, what are you talking about now? Hillary Clinton ran on the thing that I'm going to reverse what Bill Clinton had done between 92 to 2000. And Biden and Harris also ran on criminal justice reform. Harris was being attacked for being tough on crime when she was Attorney General in California. So I don't think legislators don't know. Legislators very well know what they're doing, right? That the law, criminal law, at the end of the day, is going to capture a particular class of individuals. It's going to be the poor, the marginalized, who are going to come within the purview of the criminal law. And we see provisions, again, when extensive studies in the US on white collar offenses, where they didn't bring any of these things in white collar crimes, where people could get away with multi-million dollar frauds with 6 months of punishment. Or where Paris Hilton, you went into Harrods and picked up a necklace worth thousands of dollars and got community service, right? So yeah, so I don't think legislatures are not aware, but at the end of the day, and again, more recently, we've had hardly any parliamentary debates on any of our legislation.
Yes.
Right,
Exactly.
Going back to our social order, public order, of course, it's happening in committees. Parliamentary committees are discussing this in extensive detail. Right, parliamentary committee, standing committee reports, some of them are discussing in extensive detail the problems with the legislations that are being brought in. But Parliament itself is just ignoring all of that and legislating. So I wouldn't say legislatures are not aware of of the implication that the laws are having, but I think it's a total uh, uh, not being bothered about it. And I think if we've also, with this entire thing that's also happening in India and the rest of the world, of winning that particular election, what do you need to win that election? So as long as that purpose is served, it's done. Tomorrow, how that's going to play out against you as individuals, right? We saw that happening in the context of PMLA with all the Congress leaders, right? Things that you brought in, draconian provisions, are now all being used against you when you had been warned by committees, parliamentary committees, and reports, expert committees that went in saying this is not the way to dilute your criminal justice process. So I think it neglect and disregard to say one level of intentionally bringing these provisions for whatever vested interest you have at that point of time.
So are we coming, this is something that I ask, and this is something I'm asking both of you too. Are we coming to a point where criminal law is becoming redundant? As in there's no point to it. Should we just find alternatives to criminal law?
Well, I agree with what Professor Mrinal is saying. And I think the legislature and the state more largely, I would say, is very clear-headed in its use of the criminal law. In whatever way, fair, unfair, warranted, unwarranted. They know the potential of power that criminal law subjects and gives the state over the citizen. And therefore, there is this eternal, I suppose, continuous tension that has to exist between society and the state, where the state is continuously trying to take over some liberty. And society has to push back and say, no, this far and not any further. These special laws make those inroads into liberty in specific ways. And our imagination, and when we welcome as society a special law, our imagination of how it is going to be invoked is very different from what happens in reality. And essentially we are welcoming the state into this kind of, so with surveillance, let's say, which was meant to surveil, let's say, terror operations, but is going to be used to surveil civil activists, common citizens. The examples are very numerous. So criminal law, I suppose, has always existed with this tension, right? That it exposes the individual to the vast machinery and the vast power of the state. There's nobody standing between you and the state's power except for that criminal procedure, which has to be read and interpreted in your favor. The state never needs a CRPC. The state has been executing people, putting people on trial, arresting people, and throwing people in exile for hundreds of years. Who needs the CRPC? You and I need the CRPC.
Absolutely.
So I always tell my students that you must understand the CRPC as statutory limitations on state power, on what the state can otherwise do. The state has the police, the state has the prisons, the state has the courts, etc., etc. So criminal law, I think at its heart is that political tension always exists. And you of course, I suppose every society, whatever small, big, etc., has some system of criminal law. So I would say that in a sense, that tension has to be resolved always in the favor of the accused as far as possible. And that's the only way criminal law can progress. That's how it has progressed. In the Middle Ages, we were burning people at stakes with signed confessions after torture. Then we realized, no, this is not the correct way of doing things. And we have reached a particular stage. So it's a challenge, I suppose. And these challenges have always existed. So the state is evolving in its mechanism of tricking you with regard to these things. You must now evolve in your mechanism of pushing it back. So you can't fight it with centrism. I suppose there has to be some kind of a criminal law fidelity response to it, which sadly the society doesn't have. So we are very happy to see someone else's rights being taken.
Yes, absolutely.
Yeah. In India, so why does the state even dare to have something like the love jihad ordinance, etc.? Because they know that a lot of people like this.
Yes.
And of course, what people don't realize is what you're giving the state is immense power over a spectrum, over a field of, let's say, your being, which is ultimately going to come to you.
Absolutely.
So, I suppose it's an eternal
process. We are celebrating encounter killings. So,
yes, absolutely.
So love jihad is just a part of a larger pattern that we have now started as a society following.
We don't have patience with our process.
Procedure. No, we do not. We absolutely do not. Yeah, I think we have had a long discussion. I think we'll wrap this up and we'll open. I don't know how to do this, so just to say, we'll open this to questions. Sonali, are you around to help with this?
Yeah, let me just send you one question that we've received so far.
We've received one question in all of
It's
that.
there on the chat.
Okay, 1 second. I think we've answered this.
What is the question? It's
So-
in the chat.
Yeah. So, can you open this? I think it's basic. So should I read it out? Are you reading it for yourself?
I'm reading it. Yeah.
All right.
I was trying to find, because with the question that you asked on criminal law, I have some quotation, very sad quotation somewhere about criminal law. I was trying to find that, but I'm not
redundancy of criminal law?
Yeah, something I think Marx had said some 200, long time back about the criminal law. I'll try and circle it out.
If you find it now, great. Otherwise, if you can find it and send it to me, this will be great.
Sure.
So I think, okay, so the question is on public order and whether this is we are very far from dictatorship if we start taking individuals' liberty away on the basis of public order. I think Kunal's wrapping up comments have been exactly on this, that we're giving away a lot of our personal liberty on the basis of something that we hope will make us a more disciplined society, but that's not. And I think dictatorships also pride themselves on this, right? That they are very disciplined as a society.
Yeah.
So yeah, no, to at least, but this is just me taking on the question. To my mind, it doesn't take away. It's not very different from a dictatorship. The panelists can answer this question on what they think.
I think already discussed, like you said, in a bit of detail. I think we are giving up on constitutional values, and like we both of you just mentioned, we are happy with somebody else's constitutional values being taken away because we don't think it will impact us.
Yeah.
And slowly, as you see it impacting you, is when you realize that you shouldn't have given it up at
the first place.
In the first place. Again, it's not about. I think a lot of time people think that it's about crime and I'm never going to commit a crime, so therefore why should I be even worried about some of these things? But I think again, it's not about crime. Of course, it starts coming in different ways, in different manners, which has nothing to do with crime. But once you start giving up your core constitutional principles or rule of law principles, it can come to bite you in different ways that you never anticipated in the past.
Absolutely.
Yeah.
So, thank you, Mrinal. Thank you, Kunal. Thank you for taking time out for this. And I really had a good time. I don't know what.
It was a pleasure. Yeah.
It was a pleasure. Thank you so much.
Thanks. See you.
Thanks.